Our presentation today, of course, is for educational purposes, should not be considered as legal advice or creating an attorney-client relationship. We know a number of you on with us today are our clients and a number of you aren't. But we'll be happy to answer any questions you have about the matters we're raising today. Separately, feel free to shoot us a question through the system, or you can send us an email the same way you received your invitation to attend the webinar today. We'll be happy to reach out to you and answer any questions you have. Luke, if you go to the next slide. Just to give you a little bit of background here, for those of you that are a little bit new to who we are, Holland & Hart, we're a law firm located in the Intermountain West. We have a significant healthcare team. We've handled a large number of healthcare matters for all kinds of healthcare providers, hospitals, and folks in the healthcare industry. It's a pretty significant practice for our firm with a pretty large team across several of our offices. We do everything from dealing with privacy issues to regulatory compliance to litigation and everything in between. Let me just tell you a little bit about who I am. My name is Eric Maxfield, and I practice here in Salt Lake City. I've represented several hospitals and a number of other types of healthcare organizations and companies that are in the healthcare industry, and I've done that for some time. Also helped healthcare folks that are dealing with some compliance matters. I'm also a litigator, and as a litigator, I help a number of different kinds of clients work through tricky disputes, investigations, and compliance issues. And I've been here at Holland & Hart a long time. And before that, I attended Georgetown's law school, and before that, the University of Utah. Just want to get, Luke, if you'll flip to the next slide, let me talk just quickly. Today, we're going to talk about Accra, but we have a couple of other federal fraud and abuse webinars coming up. On July 2nd, we're going to talk about federal fraud and abuse laws generally. On July 18th, we'll have another webinar about waiving copays, patient discounts, and other issues involving patient arrangements. And on August 8th, we'll be talking about compensation and perks to referring providers, some compliance traps, and some common questions. So we invite you to join those webinars on those dates. And I think our presenters include Kim Stinger, who you've probably heard before, and probably a couple of other folks from our group. Let's go to the next slide, Luke. We want to talk about Accra and what Accra is about today. And really, Accra is an attempt on Congress's part to prohibit people from referring substance abuse patients to recovery homes, clinical treatment facilities, and labs in exchange for kickbacks. That's sort of the general gist. And we're going to get into the substance today and talk about some of the challenges the law presents. But that's the basic gist. Luke, if you'll go to the next slide. Well, that's a picture of the U.S. Capitol building, and the reason we have that here, Congress is dealing with an issue that really relates to the opioid crisis. And we're going to talk a little bit today about Congress's intent as far as we can figure it out as it relates to this Accra Act. But Accra is part of a larger scheme here aimed at the opioid crisis. Luke, if you'll go to the next slide. We're not going to spend a lot of time talking about some of these details. I'm certain that many, if not most of you, if you're dealing with issues in the healthcare field, are well aware of the opioid crisis that's been going on. Basically results from a rapid increase in the use and in a number of cases the abuse of both prescription and non-prescription opioid drugs. And we're talking about oxycodone, OxyContin, Percocet, etc. Luke, if you'll go to the next slide. We don't really need to go into the reasons for the significant increase, but that increase has resulted in significant litigation around the United States. It has spawned all kinds of government responses. State and local governments have sued manufacturers. There has been administrative and law enforcement prosecutions around the country, and there's been definitely a target placed on healthcare providers, both in a criminal and a civil context, in response to these issues. Well, Luke, if you'll go to the next slide. Congress has decided to get in on the act, literally, and has passed what is called the Support Act, which you've probably heard about portions of this. This was passed last fall. The longer name of this act is the Substance Use Disorder Prevention that Promotes Opioid Recovery and Treatment for Patients and Communities Act. So that's the long name, short name, the Support Act. President Trump, he has, at the time of signing this, he called this the largest single bill to combat the drug crisis in the history of our country, and is certainly a large act. The overall purpose of the act is to prevent opioid use disorder and provide for the recovery and treatment of individuals dealing with those issues, and also to prevent the overprescription of opioids. The Support Act is a little bit of a misnomer in the sense that it is not just one act. It actually contains a large number of separate acts. I think there are 120 separate different acts contained within the act, which is sort of a legislative thing. Who does this affect? Basically, if you're in the healthcare industry in any sense, the Support Act is likely touching on what you do in some manner. But today, we really want to talk about Accra, the Eliminating Kickbacks and Recovery Act, which is a portion of the Support Act. It is a last-minute addition to the Support Act. There is a lot of controversy on how it was added at the last minute. It appears to have been added with virtually very little debate. And we're going to talk today in particular about labs, and the portion on labs was a late addition to a late addition. The Accra Act is controversial. It's ambiguous. Right now it is untested, and it definitely presents significant dangers for the folks that it is attempting to deal with. Let's direct ourselves to the next slide, Luke. We mentioned this a little bit before, but basically the intent is to prevent people from, the core intent here is to prevent people from referring substance abuse patients in exchange for kickbacks, and that's specific to recovery homes, clinical facilities, and laboratories, and we'll talk about the definitions for each of those in a minute. So what's really going on here? Why is Accra an issue? Well, there's a perception by members of Congress that there were increasing numbers, or there are increasing numbers of patient brokers. Patient brokering is where, at least in this context, a third party enrolls an addicted patient into a private health insurance plan and then arranges for that addicted patient to enter a treatment facility or a sobriety home, and apparently often across state lines, in exchange for a kickback payment. The treatment facility or the sobriety home, then bills the insurance company for treatment services, and from the government's perspective, those services are often substandard and in some cases not even provided in the first place. Because this kind of activity, the activity they're trying to get at, involves private pay insurance and not federal health care dollars, some of the legal tools that would normally be available to prosecutors or regulators are unavailable in this situation. So really, this was Congress's attempt to limit this kind of patient brokering activity that Congress felt was inappropriate. So now let's go to the next slide, Luke. Let's talk about the actual statute. In the materials that we've sent you, there's a link inside the PowerPoint. The law itself, Accra, is located at 18 U.S.C. Section 220, which you can find by either clicking on that link or Googling the statute. Let's go to the next slide. So this is the language of the statute. We're going to kind of go through these provisions and pick them apart a little bit. But you'll see here that generally it describes the offense, and that is, and I hate it when other people read PowerPoint slides to me, so I'm going to be careful here and not read the whole thing. But basically, you'll see that it talks about whoever solicits or receives, in this case, a kickback, bribe, or rebate directly or indirectly, or if you look at that subparagraph 2, pays or offers any kickback, bribe, or rebate. This is the kind of conduct that the actual statute is talking about. Let's ask this question. So what is covered by ECRA? If you'll go to the next slide, Luke. My little emoji here is a little bit facetious, but there are significant questions about what this statute is both meant to apply to and what the language appears to apply to. Let's start. If you'll go to the next slide, Luke. So this first part of the statute, I want to focus first on the word whoever. You'll see that in the first sentence it talks about whoever with respect to services, etc. Unlike other statutes, in particular like the Stark Act, that centralize themselves on doctors and providers, this act is very broad. It goes well beyond doctors and providers, and it speaks to anyone who engages in the activity that's prescribed. The statute then talks about, if you'll see here, the highlighted language, it talks about services covered by a health care benefit program. As I mentioned earlier, because the other federal statutes really deal with federal health care dollars, the drafters of this statute meant to go well beyond the federal health care dollar regime. If you'll go to the next slide, Luke. So the definition of health care benefit program in the statute is any public or private plan or contract affecting commerce under which any medical benefit, item, or service is provided to any individual and includes any individual or entity who is providing a medical benefit, etc. If you'll go to the next slide, Luke. What this is really telling us is that this is sort of an all-payer statute, not just government payers. So regardless of whether the transaction at issue involves Medicare or Medicaid, even if it's a private health insurance matter or any other payment regime, this statute is meant to reach out and touch it. Typically, if you're not talking about federal health care dollars, those kinds of transactions, if they're regulated at all, would be regulated by the states. But this statute is definitely reaching out its tentacles and saying, no, we're going to reach out to certain transactions regardless of whether they involve federal health care dollars. So that raises some compliance questions. We'll talk about a little bit more as we go on. But again, I'm trying to emphasize here that this goes well beyond Medicare and Medicaid. If you go to the next slide, Luke, you'll see here the statute in that subparagraph 1 talks about soliciting or receiving any remuneration, and it includes kickbacks, bribes, or rebates. The important point here that I want to get across is that whether you solicit or receive the remuneration, you trigger the statute. It doesn't actually matter if money passes hands. It's enough to trigger the statute if you just ask for or offer the kickback. And Luke, if you'll go to slide 18, or the next slide, we'll see here the language that's highlighted talks about pays or offers any remuneration. So again, it's not enough, it is enough simply to make the offer or the request for the remuneration. You don't actually have to exchange cash or a kickback of any sort. And when I say cash, I should clarify here that we're talking about any remuneration. It doesn't actually have to be hard cash, of course. The statute appears to be directed to any sort of thing of value that is offered, solicited, paid, or received. Let's go to the next slide. That, again, you'll see here the language referring to in cash or in kind, as I was describing. Okay, one more slide, Luke. Here you'll see that I've highlighted language referring to the word referring or referral. And again, the point of the statute is to attack the referral of patients, and again, in these certain contexts of recovery homes and laboratories that we'll talk about. There's no statutory explanation, at least right now, as to what constitutes a referral, but I think probably most folks would understand that to be trying to get a patient referred in the normal medical context. Okay, Luke, if you go to the next slide, let's focus here on who we're talking about. This key language right here is going to require some focus on our part. It says, in return for referring a patient or patronage to a recovery home, a clinical treatment facility, or a laboratory, a lab. Let's go to the next slide, Luke. So the statute defines a recovery home. It's a shared living environment that is or purports to be free from alcohol and illicit drug use and centered on peer support in connection to services that promote sustained recovery from substance abuse disorders. And there's a statutory reference there if you wanted to go track that down. But that's what the statute tells us a recovery home is. I don't think there's a lot of dispute or concern about what might fall into that particular definition. Let's go to the next one, Luke. A clinical treatment facility. So the statute, again, is talking about referrals that involve clinical treatment facilities. This is a medical setting, and I've bolded this language here, other than a hospital. So clinical treatment facilities in this context do not include a hospital. But a facility that provides detoxification, risk reduction, outpatient treatment and care, residential treatment, or rehabilitation for substance abuse. And these are the kinds of facilities that would be licensed or certified by a state. I want to point out here that the definition seems to tie the facilities to those that are for or involve substance abuse. It's a little unclear whether this applies to a non-hospital medical provider who offers multiple services, including substance abuse, but doesn't necessarily concentrate on them. I think there's an argument that if you are providing any of these services, regardless of other services you're providing, this statute is speaking to you. I think there's definitely an argument there. If you go to the next slide, Luke. Many of you listening today, you might have a lab, might even look like this picture, might not. Really here, where we get into labs, this is where things start to get a little bit tricky. Luke, if you go to the next slide. So instead of providing a specific definition for lab in the Accra statute, Congress decided instead to tie that definition to a different part of the code, the U.S. code. And here I've provided the definition for you, and I've provided the two references below. The statutory reference to Section 220, that is the reference to Accra, and Accra in turn then points to the other statute, 42 U.S.C. 263A. As you look at this definition, you're probably reading it to yourself and asking yourself whether this definition includes labs that either you have or you're doing business with. From most of the folks who have been looking at this provision since it was passed, most of the folks who are looking at this believe, as I do, that this includes well beyond toxicology-specific labs or labs that are specifically set up for substance abuse facilities. There's a debate out there, even though the language suggests any lab. In other words, if you look at the language, a facility for the biological, microbiological, etc. Assessment. Even though there's if you look at that language and you say to yourself, well, that seems to include any lab, there's a lot of chatter whether Accra was actually meant to apply to non-toxicology labs. The American Clinical Laboratory Association has actually been working with Congress and HHS to get some clarity on this issue, but right now there is no guidance. Maybe we'll see guidance out of HHS in the future, but in my mind, as I look at the definition, I think that really this definition of lab is very broad and wide, and I think it impacts potentially all healthcare providers who have anything to do with a lab. If you go to the next slide, Luke. I think I mentioned this a little bit earlier, but for a provision that was, Accra was thrown into the Support Act very late in the legislative game, and this bit about labs was thrown into the Accra portion of the statute even later in the game, which sort of suggests that maybe Congress didn't mean what it said. But regardless, today we're sitting here with language that definitely suggests we have a broad definition. We'll talk a little bit about what kind of impacts this might provide, and we're going to have some practical thoughts at the end of our presentation today. But really today, questions that should be on your mind if a lab is something, has something to do with your enterprise. Can you compensate employees based on the number of individuals referred to the lab? Can you compensate marketing employees based on the number of tests performed, procedures performed, or how about the amount billed? I think the answer to those questions is likely no, that those compensation arrangements are now prohibited by Accra. We'll talk again a little bit more as we go about that, but I want to plant those thoughts in your head. Let's go to the next slide, Luke. I want to point out this language here at the bottom. So this is frankly, this is the scariest part of the statute itself, which is telling us all of the bad things that can happen to us if we violate the statute. The fines are potentially upwards of $200,000, and even worse, at least from my perspective, the threat of imprisonment. If you go to the next slide, Luke, I want to point out that the language at the end of that statute talks about occurrence. So, from a prosecutor's perspective, every transaction is potentially an occurrence. And we've seen this in other contexts, for example, in contexts involving prosecutions of doctors for violating Stark or AntiKickback. This is a similar technique prosecutors have used. So these violations, these potential violations of Accra can potentially add up very quickly, both from a financial perspective and then, of course, from from the imprisonment perspective. So we're talking about serious stuff. If you go to the next slide, Luke. So Accra has exceptions. And these exceptions, we'll talk about these a little bit, and I want to focus on a couple of them, but there are 8 exceptions, and again, there's no regulatory guidance at this stage as to whether or not those exceptions are, or what they mean, I guess is what I really mean to say. The first exception talks about discounts obtained by service providers, and the key here is that those discounts have to be disclosed and reflected in the costs claimed by the provider or entity. The next exception, the number 2 exception here, is really where things get interesting, particularly for those of you with labs. So this really touches on the way employees or independent contractors are paid, what kinds of contracts or employment agreements or policies you have with respect to those individuals. And the point to this, and I alluded to this when we talked about labs, is that the payment to the employee, you will fall under this exception as long as your payment is not tied to how many individuals are referred to the recovery home, the clinical facility, or the lab, or the number of tests performed, or the amounts billed to the health care benefit program. For those of you that are familiar with the anti-kickback law, and we'll talk about that a little bit more later today, we're not getting into detail on anti-kickback today, but we want to point out that these exceptions are narrower than the anti-kickback statute. So even though in some instances a volume-based commission might work under anti-kickback, a lab that does that in this context under Accra has risk. So there's also, you'll see the third exception involves discounts by drug manufacturers. It's probably not an issue for most of those of you joining today. But the fourth exception is related to the federal anti-kickback statute. So that's the other one I wanted to focus on for a second. A payment made by a principal to an agent is compensation for services of the agent under a personal services and management contract that otherwise meets this anti-kickback statute exception overlaps with this Accra exception. So the point we're making with this exception here is you basically now, if you fall under the statute as a recovery home, clinical treatment facility, or a lab, you're going to have to start sorting through both the anti-kickback statute safe harbors as well as Accra's safe harbors. You'll see here 5, 6, and 7 on this list. Those are really aimed at medically underserved populations and payments related to those. Certain alternative payment models that HHS has determined are appropriate for care coordination or value-based care. And then the last, I missed number 5. Certain waivers of coinsurance and co-payments. Those are allowed as long as they're not routinely provided and they're provided for good faith. And this is a little bit different from the way the anti-kickback statute works. And then there's this last exception, number 8, any other regulatory safe harbor that the Attorney General and HHS determine are clarifications of the other exceptions. So Congress has provided a tool for the regulators to explain how some of these Accra exceptions will be defined, and I think we're looking forward to that guidance in the future, because I think these exceptions and how they work with the anti-kickback statute are definitely complicated. If you'll go to the next slide, Luke. The next slide deals with the Anti-Kickback Statute. And again, we're not going to go into great detail here, but for those of you who are unfamiliar with that statute, that basically makes it improper for anyone to solicit, receive, offer, or pay remuneration in exchange for referring patients to receive services that are paid for by the government. That's the general gist of the Anti-Kickback Statute. Some of the commentators view Accra as an expansion of AKS, or the Anti-Kickback Statute. I'm not sure that that's sort of a fair way to describe it. I think that Accra is in many ways, I don't know that I would call it an expansion as much as sort of an awkward sister of AKS. The exceptions, as we mentioned before, they don't necessarily or entirely overlap. Accra's exceptions definitely look more narrow than the AKS exceptions. And then you'll see here on our slide, I've got a bullet point about arrangements that are prohibited by AKS, not subject to additional Accra liability. You'll see my language there. Really, what we're talking about here is, from our understanding of the statute, if you're already in trouble with the Anti-Kickback Statute, that should not mean that you get additional hits or additional penalties under Accra. That's how the language of the statute has been interpreted by commentators, but we haven't necessarily seen that interpretation play out with prosecutors or courts. So again, if you have already figured out that your relationships and your marketing, etc., if you've determined that those are squarely within an exception under the Anti-Kickback Statute, I think what we're trying to tell you today is you should not assume that you are safe under Accra. Let's go to the next slide, Luke. One complicating factor that, again, has yet to be tested is Accra's relationship to state law. So under the law, in some cases, Congress will explain in new statutes whether a federal law is going to take precedence or sort of crowd out state laws that are dealing with the same subjects. In Accra's case, and sometimes Congress does this and sometimes it doesn't, this is a legal doctrine called preemption. In Accra's case, Congress put in this provision that says that Accra shall not be construed to occupy the field in which any provisions of Accra operate to the exclusion of state laws on the same subject matter. Well, this raises an interesting question. I mean, there are many commentators who think that language is vague and doesn't necessarily answer the question of what do you do if your state has a law that deals with similar issues that Accra deals with, and more particularly, what if those are inconsistent? And again, we can't answer today on a state-by-state basis sort of where this sits with your particular situation, but it definitely calls into question what are you going to do, and it certainly merits closer scrutiny of both your specific situation as well as Accra and any state laws that might apply. Let's go to the next slide, Luke. So I've alluded to this before, sort of the question of what's going to happen next. There's definitely potential and pressure on both Congress as well as the regulators to provide some more clarity. Will those regulations address some of this state and federal confusion that I just talked about? Will it talk about the intersection of Accra as well as the Anti-Kickback Statute and perhaps STARP? Is it possible for the federal government to reduce the scope of Accra, particularly as it relates to labs? Well, these are all open questions, none of which we have answers to, at least as of today. This is a new tool for prosecutors, and I think what we certainly intend to tell our clients, and we tell you today on the phone, is don't be the guinea pig. Don't put yourself in a situation where you become the new test case for what these provisions mean. There are yet to be any significant case law interpretations of the statutes. We will start to see how the courts deal with the questions that we've raised today, but that's going to take time to work its way through the system. I expect that these are answers that we won't get for a few years. Let's go to the next slide, Luke. I want to just provide some practical thoughts for you as you think through some of the issues that are raised today. Obviously, the criminal penalties are very serious, and I think with Accra, as well as the Support Act, as well as a greater emphasis on opioid issues, providers can expect greater scrutiny from prosecutors and regulators. So what should you do? Our first and foremost suggestion is we firmly believe that everyone needs to start conducting a risk assessment of your financial arrangements and relationships. That's probably the most important task you need to carry out. That likely requires you to collect contracts and related documents, matters that relate to how compensation is being paid, particularly as it relates to labs. We think folks out there need to be mindful of all their financial relationships, not just pure marketing arrangements. For example, if you have someone who is a salesperson related to a lab, that shouldn't be the only thing you're looking at. You should also be considering vendor relationships and the like, independent contractor relationships. We would tell you, if in doubt, you should be conservative, at least today, until there's greater clarity. For labs in particular, the safest thing you can do is to pay a straight salary. Now, this creates some business challenges if you're trying to incentivize the salesperson to hustle in new business. But with this minefield of Accra, there are just a lot of challenging questions here that you need to be careful of. And we realize, this is a challenging business question for many enterprises. And then finally, of course, we're lawyers. You'd expect us to say this, but because this is really complicated stuff, as you go through your risk assessment, we think you should give serious thought to raising these issues with your legal counsel, talking through the questions you have, the arrangements you have. Your lawyer, your legal counsel, whether in-house or outside counsel, can help you think through who you need to talk to within the company to sort out these issues, etc. So we definitely recommend you get legal counsel to help you sort through what is in many ways, a laudable attempt by Congress to protect people, but definitely raises a lot of complications for providers and all kinds of folks that are in the healthcare industry. Well, I've talked a lot. I want to thank you for your patience today. You can go to the next slide, Luke. We've recorded this webinar, and our materials today are going to be on our Health Law blog. If that is new to you, I want to just highly recommend that you check out our Health Law blog. We regularly post there. It's searchable, so you can go back and find both webinars that we've done as well as other content, written content. And often some of the simpler questions that you come across in your day-to-day can be answered with some of that content. But some of that might also raise other questions you have about your particular situation. If you have additional questions, I want to recommend that you talk to our folks, Christy Kimball, Kim Stanger, Blaine Bernard. They are health lawyers extraordinaire. I'm just highly impressed with all of them, and would recommend you reach out to them. You can also reach out to me. And I want to thank you again for joining us today, and hopefully we've been able to provide good thoughts and good content today. Thanks a bunch, and look forward to talking to you another time.